The Second Amendment to the U.S. Constitution is a mess, a muddle, a grammatically challenged pair of clauses that allows two or more readers to insist that it says two starkly different things, both of which are of life or death importance and each of which can be only partially defended. To some, it is foremost the Militia Amendment, plainly referring to the people as a collective entity and embodying a young, rebellious nation's mistrust of professional standing armies in favor of armed citizens banding together at times of crisis. Yet to others, it is primarily the Gun Rights Clause, safeguarding an individual's right to keep and bear arms, notwithstanding the clear references to the security of a free state and the lack of any mention of individual rights. The drafters of the Bill of Rights were learned men who knew how to write, so there must have been some reason for them to submit these oddly assembled 27 words that give us such trouble today. They most likely disagreed over the place of firearms in American society. Was their primary and most contentious purpose to defend the nation, against foreign invaders, but perhaps also against the abuses of their own government? Or was it for shooting squirrels for the dinner table, and defending against slave revolts and Indian uprisings? In its 2008 Heller decision, the Supreme Court upended a shaky but century-long, and quite reasonable, presumption that the Second Amendment applied to militias. Writing for the majority, Justice Antonin Scalia asserted that it guarantees an individual's right to have a gun at home, even if the purpose of having the weapon goes beyond joining the local militia in response to emergency. That ruling opened up the prospect of an even greater proliferation of deadly weapons in what is already the most heavily armed nation. In arguments to be heard Wednesday in New York State Rifle and Pistol Association Incorporated versus Bruen, the court considers whether it is constrained by Scalia's limitations and how far they reach.